Refugee law training. Training for South African legal and paralegal practitioners to understand the basic principles of refugee status determinations for LGBTQIA+ asylum claimants. Exclusion criteria. Exclusion from refugee protection under the 1951 Convention means that an individual who fulfills the criteria for inclusion cannot nevertheless benefit from refugee status because he or she is not in need or not deserving of international refugee protection. There are three groups of persons that are excluded from refugee protection: those already receiving United Nations protection or assistance, those who are not in need of international refugee protection, and those that are not deserving of international refugee protection. Persons not considered to be in need of international protection. Article 1E of the 1951 Convention provides that the Convention would not apply to a person who is recognized by the competent authorities of the country in which he has taken residence as having the rights and obligations which are attached to the possession of the nationality of that country. This exclusion would only apply if the claimant has been granted permanent residence or other residence besides citizenship and has or enjoys rights and obligations of nationals of that country. The status afforded to the claimant must provide protection against refoulement and allow them the right to return or re-enter and remain in the country. Persons not deserving of international refugee protection. Article 1F of the 1951 Convention provides the instances where a claimant who would otherwise qualify for refugee status is not deserving of international protection and thus excluded from refugee status. The Convention will not apply to a person where there are serious reasons to believe that they committed a crime against peace, a war crime, or a crime against humanity as defined in human rights instruments, committed a serious non-political crime outside the country of refuge prior to his admission into that country, and they are guilty of acts contrary to the purposes and principles of the United Nations. The main reason for excluding claimants from international refugee protection is to deny persons who have committed heinous acts and serious crimes from receiving international protection and to ensure that these persons do not abuse the asylum process to avoid being held legally accountable for their acts. Application of Article 1F of the 1951 Convention. The exclusion clauses are an exhaustive list and should be applied restrictively, cautiously, and in the following manner. Inclusion criteria should be considered first before examining the exclusion criteria. When considering whether there are serious reasons for considering that a claimant has committed an excludable act, clear and credible information is required. The standard of proof need not be beyond a reasonable doubt, but it should be more than on a balance of probabilities. The burden of proof lies with the decision maker, and only in exceptional cases will this burden shift to the claimant. There are 4 steps to determine whether a claimant comes within the scope of an Article 1F exclusion: determining whether an exclusion is triggered, determining whether the claimant is linked to any of the acts that fall within the scope of Article 1F, determining whether the claimant incurred individual responsibility for these acts, determining whether the exclusion would meet the general legal principle of proportionality. Determining whether an exclusion is triggered. Generally, this would arise during the interview with the claimant and would be triggered by statements made by claimant themselves, or they may be triggered by other information that would suggest that the claimant is associated with an excludable act. Determining whether the claimant is linked to any of the acts that fall within the scope of Article 1F. Article 1F exclusions are an exhaustive list, and only those acts listed under Article 1F give rise to an exclusion. Article 1FA: Crimes against peace, war crimes, and crimes against humanity. Crimes against peace. A crime against peace involves the planning, preparation, initiation, or waging of war of aggression, or a war in violation of international treaties, agreements, or assurances, or participation in a common plan of conspiracy for the accomplishment of the foregoing. War crimes are serious breaches of international humanitarian law and that are committed during armed conflicts or linked to the armed conflict. War crimes can be committed by and against civilians and military persons. Serious violations of international human rights laws may also give rise to individual responsibility and could be considered a war crime. Crimes against humanity are inhumane acts, genocide, murder, rape, and torture, when committed as part of a systematic or widespread attack against a civilian population and can take place during an armed conflict or not, and be committed by any person. Article 1FB. Serious non-political crime committed outside the country of refuge. Whether a claimant has committed an act that constitutes a serious crime should be judged against international standards, and whether or not a crime is non-political will depend on several factors, including the motivation, context, and method of the crimes, as well as the proportionality of the crime in relation to its objectives. Article 1FC. Acts contrary to the purposes and principles of the United Nations. Any act that is contrary to the purposes and principles set out in the UN Charter. Determining whether the claimant incurred individual responsibility for these acts. When it has been established that the claimant has been connected to an excludable act, the next step is to determine whether the claimant is individually responsible for the excludable act. This will be present if the claimant committed the act themselves, the claimant participated in the act committed by other persons, such as planning, ordering, or instigating the commission of the act by others, the claimant made a substantial contribution to the act by aiding and abetting or participating in a joint criminal enterprise. Further considerations. Persons in positions of authority may be held responsible for crimes committed by their subordinates. The claimant must have the necessary mens rea in the commission of the act, that is, they must have the necessary intent in the commission of the act, and the knowledge and appreciation of the consequences of their actions. Additionally, it is important to establish whether the claimant has a valid defense that would exempt them from liability. Determining whether the exclusion would meet the general legal principle of proportionality. Interviewers and decision-makers should weigh the seriousness of the crime against the potential consequences for the claimant. Cessation. Refugee status by its very nature was intended to be temporary in nature, and as such there are instances where international refugee protection is no longer needed. If a refugee can safely return to their country of origin or habitual residence, then international protection is not justified or necessary. The 1951 Convention lists an exhaustive list of circumstances where refugee status will cease. The cessation clauses must be interpreted restrictively and with procedural safeguards in place, including the ability for a claimant to challenge the decision to remove their refugee status. Article 1C of the 1951 Convention envisages two categories of situations where cessation would apply: acts by the claimants giving rise to cessation, fundamental changes in the country of origin or habitual residence. Acts by claimants. A claimant will cease to be a refugee if they voluntarily re-avail themselves of the protection of their country of nationality, or having lost their nationality, voluntarily reacquires it, or acquires a new nationality and enjoys the protection of that country, or voluntarily re-establishes themselves in his country of origin. Fundamental change in the circumstances. Refugee status may be revoked if the reasons they fled their country of origin or habitual place of residence cease to exist, provided that there aren't compelling reasons arising out of past persecution why they cannot return. The cessation clauses are applicable if objective circumstances in the country of origin or former habitual place of residence have changed fundamentally and such change is stable and durable. The compelling reasons exception reflects a general humanitarian principle that a claimant or their family who has suffered severe forms of persecution should not be compelled to return. General procedural considerations. Interviewers and decision-makers should consider the following additional procedural considerations in refugee status determinations for LGBTQIA+ refugee claimants. Issues pertaining to the interview process. LGBTQIA+ claimants should be provided with a safe and supportive environment throughout the refugee status determination process. Confidentiality is an essential condition of all refugee status determinations. The decision-maker should assure the claimant at the outset that all aspects of their claim would be treated in confidence. Interviewers or decision-makers should be objective and not draw conclusions based on stereotypes of LGBTQIA+ persons, such as drawing conclusions about how the claimant behaves or appears. The interviewer or decision-maker should use words that are not offensive and shows a positive disposition towards diversity of sexual orientation and/or gender identity. An interviewer or decision-maker should acquiesce to a request by a LGBTQIA+ claimant for an interviewer of a certain gender. Directing questions to a LGBTQIA+ refugee claimant about sexual violence should be treated with the same sensitivity as generally applied to other survivors of sexual violence. Women refugee claimants should be interviewed separately from male family members. Child claimants should be given specific procedural safeguards, such as prioritizing the processing of their claims, appointing a legal guardian, and providing them with legal representation. Discrimination, hatred, and violence can impact the claimant's ability to present their claims, and in some instances, the claimant may still not be comfortable with expressing their sexual orientation and/or gender identity. Adverse judgments should not be drawn by the claimant not declaring their sexual orientation and/or gender identity at the pre-screening or first interview stage. Guidelines on credibility assessments. The assessment of credibility of a LGBTQIA+ claimant must be done in an individualized and sensitive way. The interviewer or decision-maker should focus on exploring the claimant's personal perceptions, feelings, stigma, and shame rather than on their sexual practices. Self-identification as a LGBTQIA+ person should be regarded as the claimant's sexual orientation and/or gender identity, while instances where the claimant does not readily identify as LGBTQIA+ alone should not rule out the claimant's asylum claim. A transgender person not undergoing gender-affirming treatment or surgery should not be regarded as evidence that they are not transgender. A failure to disclose their sexual orientation and/or gender identity to family members or friends, or that the claimant was married or had children, does not in itself mean that they are not a LGBTQIA+ person. The claimant not having past or present romantic or sexual relationships does not mean that they are not LGBTQIA+. A claimant's lack of knowledge of LGBTQIA+ community meeting places and activities, interactions with other LGBTQIA+ persons, or failure to join LGBTQIA+ groups in the country does not mean that they are not LGBTQIA+. Evidentiary issues. The claimant's story is primarily the only source of evidence. The claimant should never be asked to produce documentary or photographic evidence of intimate acts, and it would be inappropriate to ask a claimant couple to physically demonstrate their relationship to prove their sexual orientation. The claimant cannot be asked to undergo medical testing to prove their sexual orientation, as this would be a violation of their basic human rights. The lack of relevant country of origin information on the situation and treatment of LGBTQIA+ persons should not automatically lead to a rejection of the claimant's application for asylum. This training video was developed by the Legal Resources Center and funded by the Embassy of the Kingdom of the Netherlands in Pretoria, South Africa.